Good morning, everyone. Thank you for joining us for today's webinar. My name is Alex Pyle, and joining me on the panel today are Brian Bouchard from our Labor and Employment Group, Paul Royland from our Corporate Transactions Group, Peter Beach from our Tax Group, and Paul Durham from our Corporate Transactions Group. I'm going to make a few announcements and then we'll get started. We have a full agenda today, so we'll try to keep things moving as briskly as we can. First, if you have questions during the webinar, there is a chat function at the bottom of your screen. Feel free to use that to submit questions. We will try to either answer them during the presentation or at the end as time allows. We're required to inform attendees that this webinar is being recorded and will be made available on our website afterwards. Also, I'll just note that while the information we provide today may include some general guidance, it's not intended nor is it a substitute for any actual legal advice. Finally, I'd just like to let everyone know that we'll be doing another webinar next Wednesday, same time, 11 a.m. On employment matters specifically, and hope you can join us then. Without further ado, let me just briefly review the agenda and we'll get started. So we'll start with a discussion of some employment issues that come up in this current environment. We'll talk about some of the recently enacted loan programs under the stimulus legislation that's available to small businesses. We'll speak about tax benefits for businesses that may be available. And some discussion of contracts and how they can be impacted by this kind of an event and options that you may have under contracts in that situation. And finally, we'll speak a bit about insurance coverage issues. So we have 30 minutes. It's going to be a full agenda. Thanks again for joining us. And now I'll pass the discussion over to Brian Bouchard to speak about employment issues.
Good morning, everybody. Thanks for being here. My name is Brian Bouchard. I'm a member of the firm's Labor and Employment Group, as well as the Litigation Group. And this morning, I want to talk through some targeted questions that are related to the Paycheck Protection Program, as well as the Families First Coronavirus Response Act. So dive right into it. One of the questions we've been receiving is, what happens at the expiration of the PPP period if an employee then requests leave and is potentially out for potentially 12 weeks, is there any way that we can protect ourselves? And I think this question comes from a good place. If the company is trying to survive through a PPP loan and then might not be able to sustain potentially 12 weeks of paid leave afterwards. And so I would start and preface my remarks by saying that as a threshold matter, if an employee is entitled to leave, then leave should be granted. At the same time, there are ways to work within the FFCRA that might be able to benefit the business. One thing that businesses should explore is whether they're entitled to a small business exception for the leave being requested. And that's going to apply if the business has fewer than 50 employees, if the type of leave being requested is related to the unavailability of childcare, and providing the leave will result or threaten the economic viability of the business. And recently, the US DOL has published regulations that define what such type of economic hardship would look like. And there's three sets of circumstances. The first circumstance is that if leave is going to be provided, the expenses of the business are going to exceed revenue such that the business won't be able to operate or will only be operating at a minimal capacity. Effectively, the economic hardship is going to be such that the business is going to be forced into a type of hibernation. That's one circumstance in which the business might be able to claim an exception to the FFCRA leave. The other is that the employee requesting the leave or the set of employees requesting the leave are really so necessary to the business that their absence will entail a substantial threat to the financial health of the business, as well as the operations of the business. One way to think about this is if you have a program manager or a product manager who is heading a project that is about ready to launch, and then that person requests potentially 12 weeks of leave, will the business be able to sustain that? And the final circumstance is that there simply are insufficient workers or replacement workers to keep the business afloat if the FFCRA leave is granted. If you think that you are a business that may qualify for the small business exception, I encourage you to consult with counsel about it. It's not something that you're going to apply for the USDOL for, at least not yet. Rather, an authorized officer of the company is going to make the decision as to whether to claim the exception, but then is also going to have the responsibility of collecting all documentation related to the exception and holding that documentation for a period of 4 years. The other thing to consider with regarding FFCRA leave is that the leave isn't just simply available to all employees at whim. There are certain set of circumstances that must be met for the leave to be provided. And one of the things I want to talk about very quickly this morning is the leave related to childcare. Or the unavailability of childcare. It's that a school is closed, a daycare is closed, but also that there is no other suitable person available for the leave. And one of the questions we've been seeing about this is, okay, well, what is being defined as a child? Is there an age threshold? What if I have an employee that has someone who has a 15-year-old and they're saying that they have to stay home and care for that person? And what we have here is a situation where the USDOL may not be talking with the IRS about the leave in question. The regulations have adopted the definition of son and daughter from the FMLA, which broadly speaking says that a son or daughter is anyone under 18 years of age. At the same time, in order for an employee to obtain the leave, they have to provide all documentation needed for the tax credit. And the IRS has said that if the leave is related to the care of a child who's 14 years or older during daylight hours, that the employee must provide a statement of special circumstances as to why such leave must be provided. So on the one hand, the leave is available for an employee caring for children under 18, but if the child is over 14, the employee must provide a statement of the special circumstances as to why such leave is needed. The other thing to talk about this morning is the potential relationship between PPP loan and the tax credits available through the FFCRA. One question we've been receiving is whether a company can take advantage of both the PPP loan and the tax credits that are available for leave. And the short answer is no, you can't. That would be considered double dipping. What would happen is if you are planning to take the tax credit for the wages that are being paid out, those type of wages are excluded from the definition of payroll costs under the PPP program. And finally, one thing that's emerged is companies having concerns over how to treat an employee's resignation or termination under the PPP program. As you know, there's a head count that has to be maintained that may affect forgiveness, and employers are concerned about if an employee quits or if an employee rightly needs to be fired, will that potentially affect the forgiveness of a loan because the head count will be reduced. And right now, it seems to be that it would have an effect. The regulations so far have not created any type of caveat for an employee who resigns or an employee who has to be fired for legitimate circumstances in relation to headcount. What we would recommend is that if you are in that circumstance, to hire an emplacement employee as soon as possible so that the headcount can be maintained. And that's all for my time this morning. I'm going to turn you over to Paul Royland now. Thank you.
Thanks, Brian. I'm Paul Royland. I'm a member of the firm's corporate department. You should have received in your email a chart that we prepared outlining many of the basics of the economic injury disaster loans, as well as the Paycheck Protection Program. If you don't have it, you can access it on the firm's resource webpage. I hope that will be a valuable tool as you work to navigate your way through those programs. But for our time today, what I'd really like to focus on is some of the questions we're seeing with great frequency from our clients about these two programs. The first area we're getting a lot of questions has to do with how do I calculate my payroll costs for purposes of the Paycheck Protection Program loan? We all know the basics: wages, vacation, healthcare, retirement benefits, sick and family leave, all count towards that calculation. Where things get a little more nuanced are when we get to taxes. Now, taxes that are imposed on an employee and withheld by the employer are counted toward the loan amount. Any taxes that are the responsibility of the employer do not count. By way of example, an employer's portion of FICA taxes would not count towards the calculation of the loan amount. We've also been asked whether or not amounts paid to independent contractors can count towards your Paycheck Protection Program loan. The Treasury Department has issued guidance stating that no, amounts paid to independent contractors do not count. We've also had some questions about how to treat employees who are compensated over $100,000 or in the range of $100,000. As you know, there's a cap on that. Now, when calculating that figure, the only amounts that are going to apply are going to be wages. It would not include any amounts paid to that employee by way of healthcare benefits or by way of retirement contributions made by the employer. It also would not include state and local taxes that were imposed on that employee's salary. One area where we're still waiting for some guidance, and we hope that it will be coming soon, has to do with workers' compensation. We've taken the position that workers' compensation is not includable when calculating your payroll cost by virtue of the fact that the guidance to date has not specifically identified it as such. Now, when employers are calculating the time periods for which they are putting together their employee costs, they have two options. They can either rely on their 2019 payroll numbers, or they can choose to use the 12-month period immediately preceding the date of the loan application. We've heard that many employers are relying on their payroll service providers to give them that information, and this is fine. But we would recommend that you do some diligence and check it, because ultimately the applicant is the one who's going to be certifying as to the accuracy of the information. Another area where we're getting a fair amount of questions has to do with the forgiveness under the Paycheck Protection Program loan. Now, the basics are, of course, that you need to maintain the 75-25 ratio. That is, 75% of the funds need to be used for payroll costs. The remaining 25 can be used for other permitted purposes. But the question comes up a lot: what if I've already laid off my employees and I still want to apply to this program? Does that somehow make me ineligible, or does it impact the forgiveness? Now, employers have until June 30th to rehire their employees and restore them to their previous compensation levels under the program. Sometimes that necessitates the question, well, what if I don't want to bring all of my employees back? I only want to bring a few of them back. And the answer to that is it's fine. There's no obligation that you rehire all of your employees. But we ask that you be mindful of the fact that this could influence the forgiveness down the loan, because the amount that you'll receive will be based upon a count when you had a higher number of employees. So just be mindful of keeping that 75-25 ratio intact. We've also been asked, what is the time period in which the funds need to be used in order to be forgiven? A borrower will have to use all of the funds under the Paycheck Protection Program within 8 weeks beginning on the date of the disbursement in order for them to be forgivable. Now, we're still waiting some guidance on how a borrower would actually go and seek forgiveness from the bank. But generally what we understand is that it will be the obligation of the borrower to present their banker with records indicating that they've complied with the program, they've maintained the 75-25 ratio, and that the funds have been used for a permitted purpose. We understand that once these documents are presented to the bank will have 60 days in which to make a decision on forgiveness. From a practical perspective, we are advising all of our clients to open a separate bank account or a sub-bank account in the event that they receive PPP funds, in order to ease the reconciliation at the end of the 8-week period. Another area we're seeing a lot of confusion and questions has to do with the $10,000 advance under the economic injury disaster loans. Early on, there was the perception out there that this was a $10,000 grant that the SBA was giving to essentially any business that bothered to submit an application, and that it was fully forgivable and there was no expectation that it would be repaid. It is true that any advance does not need to be paid, but the grant is not guaranteed to be $10,000. It will be up to $10,000. We've been hearing from the Massachusetts SBA that the advance amount is going to be calculated based upon the number of employees an applicant has. Specifically, for each employee that the applicant have, they will be given $1,000 up to $10,000. We would like to remind you that any advanced funds that are still received still must be used for a permitted purpose under the program. And as a practical matter, we're just advising people to get those applications in as soon as possible because the processing has been extremely slow. The SBA really doesn't have the capacity to handle the volume of applications that they're seeing at this time. We've also heard that the maximum loan amount, which was initially set at $2 million, has been revised downwards, given the high volume of applications and the limited amount of funds that are available. A few of the final questions that I want to run through really quickly have to do with how can the funds be used and whether or not an applicant can apply to both the Paycheck Protection Program and the Economic Injury Disaster Loan Program. And the answer is yes, an applicant can certainly apply to both of those programs, but they should be cautious about double dipping. For example, a scenario in which you used funds that were received through the EIDL program to pay payroll, whereas you had already accepted funds from the PPP specifically for that purpose. We've also been asked whether or not PPP or EIDL funds can be used to refinancing existing debt. The answer to that question is no. And I'd advise you and recommend that you consult our chart to see some of the permitted uses of the funds. We've also been asked whether or not the funds from the PPP or the EIDL program can be used to pay for sick leave. The answer is yes, that's a permissible use. We've also been asked whether or not foreign businesses can apply for Paycheck Protection Program funds. The answer to that is yes, provided that the entity has 500 or fewer employees, all of which have a principal residence within the United States of America, and they meet other eligibility requirements. So the guidance on both of these programs is changing quickly, and we expect more substantive guidance in the future. So to the extent that you have any questions that answers aren't available on the chart that we've provided or other sources that are out there, guidance will likely be coming in the future. And to the extent that you have further questions, feel free to contact me offline. And that brings my time to a close, and I will turn it over to Peter Beach for some tax advice.
Thanks, Paul. So there's going to be a bit of a whirlwind tour of the recent coronavirus tax legislation. So the first item on the chart you see involves the FFCRA tax credit that relates to qualified sick and family medical leave wages. So what's going on here that you might not have known already is that the IRS has expanded the taxes that you can apply the credit against to include not just the employer portion of Social Security tax, but both the employer and employee portions of both Social Security and Medicare tax and federal income tax withholding. Also, the CARES Act amends the FFCRA to allow the IRS to provide advanced credits on a quarterly basis rather than waiting to respond to filed forms 941 rules and procedures yet to come on how that's actually going to happen. The next item is the employee retention credit. This is a fully refundable tax credit for eligible employers. It equals 50% of qualified wages, including qualified health plan expenses, up to $10,000 per employee. It applies to qualified wages paid after March 12th, 2020 through the end of the year, and it must be reduced by the FFCRA credit. So as we talked about earlier, no double dipping. To be eligible, an employer has to carry on a trade or business during 2020 and either fully or partially suspend operations during any calendar quarter in 2020 due to a COVID-19 related government order, or experience a greater than 50% decline in gross receipts as compared to the corresponding calendar quarter in 2019. So for employers with more than 100 full-time employees during 2019, the credits available for certain wages paid to employees who are not providing services as a result of a suspension or slowdown. And for employers that had 100 or fewer full-time employees during 2019, the credits available for wages paid to any employee during a suspension or slowdown, whether they are providing services or not. And lastly, the employee retention credit cannot be claimed by governmental employers, self-employed individuals for their own services, and employers that receive a PPP loan. The next item is a new law that allows employers to defer payment of the employer's share of employment tax due between March 27, 2020 and the end of the calendar year. But they have to pay back half of the amounts deferred by December 31, 2021, and the other half by December 31, 2022. Self-employed individuals get similar treatment with respect to 50% of their self-employment tax liability. Also, employers that receive a PPP loan and take advantage of the debt forgiveness provisions can't use this deferral past the date the loan is forgiven. So it would accelerate the deferral repayment dates. The next item expands tax-free educational assistance plans to include an employer's repayment of an employee's pre-existing student loan debt. And this applies to student loan repayments made between March 27th, 2020 and the end of the calendar year, and is subject to all of the existing requirements for education assistance plans, including the annual cap of $5,250 per employee. Next item, moving on to some income tax items, involves net operating losses. And if they arise in a tax year beginning after 2017 and before 2021, so 2018, 19, and 20 for calendar year taxpayers, those net operating losses can be carried back 5 years, and they can be used against 100% of taxable income for tax years beginning before the end of the 2020 calendar year. And obviously, to secure some of these benefits, you're going to need to amend prior returns. Next item has to do with the existing limitation on annual business losses for non-corporate taxpayers of $250,000, $500,000 annual business loss for married filing jointly. And the CARES Act suspends this limitation for taxable years 2018, 19, and 20. So this should allow affected taxpayers to take advantage of a greater amount of business losses by amending returns for 2018 and 2019 if the returns have already been filed, and reporting greater losses on any initial filings through 2020. Next item allows taxpayers that previously could only deduct interest up to a limit equal to 30% of adjusted taxable income to deduct interest up to 50% of adjusted taxable income for tax years beginning in 2019 and 20. In addition, affected taxpayers can elect to use the adjusted taxable income for a tax year beginning in 2019 to determine the amount of interest deductible in 2020, which will help those that have lower adjusted taxable income in 2020 as a result of COVID-19. And these revised limitations apply differently to partnerships, but we just don't have time to get into that here. The next item, businesses that make property improvements to an interior portion of an existing building that's a non-residential real property, referred to as qualified improvement property, can take advantage of 100% bonus depreciation. This is a correction to a glitch in a prior tax act, and it's effective retroactively to January 1, 2018. So businesses can take advantage of the correction by using the treatment going forward, and also by amending prior year returns or filing for an automatic accounting method change. That's a little more complicated, but your accountant can help you figure it out. Next item is here just to remind you that the PPP loans that are forgiven, and we got a question on this already, will not be treated as taxable cancellation of debt income. And the last item relates to the corporate alternative minimum tax. The law that repealed the corporate AMT as of 2018 allowed taxpayers to take a refundable AMT credit under a formula through tax years beginning in 2021. And under the CARES Act, corporations can recover those AMT credits immediately, either in the form of a refund or a credit to offset current year tax. So one final point, the law itself isn't that hard to digest on a macro level here, but IRS guidance is crucial to many of these points, and procedures for accessing the benefits of the legislation are evolving on a daily basis. So more often than you like, you may hear, we just don't know yet, or I'll have to look into that from your tax advisors in response to some of your questions. So that's it for tax, and next up is Paul Durham.
Thanks, Peter, and thanks everybody for joining. We spent a lot of time talking about what is new legislation, but I thought one of the things we thought would be helpful would also be to discuss some practical suggestions and existing issues with contracts and performance under those contracts. So normally in times like this, it might not be uncommon for a business or an individual to say, look at their contracts and say, we can't perform, we have to suspend performance given everything that's going on in the world. Or similarly, you might receive notice from a contracting partner of the same issue. And while first instinct might be, well, we're all in this together, and so that should be okay. That's not necessarily the way things always work. And as we sort of approach and reach a new norm, as we come out of this, parties may be more likely to look at their contracts and be less sympathetic to non-performance where it is or is not permitted under a contract. So non-performance under a contract, put simply, is a breach, absent some sort of valid excuse either under the law or by contract. So one of the first things that you want to look at in this circumstance is what's commonly known as a force majeure provision or a force majeure clause in your commercial contracts. Now, these are provisions which sometimes they're often referred to as boilerplate. People don't always spend as much, they don't give enough attention to them oftentimes, and really they're oftentimes overlooked except in circumstances like this. So what the force majeure provision, there's no one size fits all. They're in many commercial contracts, but not all. So you really have to look at the four corners of your agreement and see what it has to say. Now, if there is a force majeure clause in there, it'll have some sort of definition as to what is an event of force majeure that will qualify. And sometimes that definition can be very broad. It might be something as simple as an unexpected occurrence that's outside of a party's control. And in the event of that occurrence, performance might be excused under the language of the agreement. Other times, the terms of the definition of force majeure is much more specific. It might itemize things like common see language like flood, labor strike, government action, or the broader term act of God. Less often, some contracts you do, although in many cases we don't see a specific reference to an epidemic or a public health crisis. And in circumstances like this, obviously, if you have that language in your contract, you're going to be in a much better position than if you do not. So when you look at a definition that doesn't specifically talk about an epidemic, a pandemic, a health crisis, you're going to have to look at how your contract language would be interpreted under applicable law. So another important provision in your contract will be what law applies. Is it New Hampshire? Is it Massachusetts? Is it New York? Is it somewhere else? And again, that's built into the contract itself. One thing to be aware of is if again, just speaking generally, because this is going to vary by circumstance. If your contract does not specifically reference an epidemic or a health crisis, but does include just that broad language, you're probably going to have a better argument that would, act of God or an unexpected occurrence is going to cover something like COVID-19 or some other health situation. If, on the other hand, your contract is very specific and lists in great detail the types of things that are considered an occurrence of force majeure, then you may be less likely to succeed in saying that an epidemic would be covered. Again, like many things in law, the ultimate answer is, unfortunately, it depends, and it really depends on the circumstances of what you're looking at. I will say going forward, of course, we're still drafting contracts for clients all the time, and force majeure provisions. Clients are and contracting parties are, for obvious reasons, paying a lot closer attention to it now. And one thing that I will say is that what I'm recommending is, as you go forward, COVID-19 is no longer an unforeseen circumstance. So it's really important to consider how you're going to treat this event and bargain for it now, because you'll be less likely to be able to make the argument that you didn't see this coming going forward. Now, if assuming that the event does amount to an event of force majeure under your contract, you still need to be careful to provide notice. That provision will have things like what you need to do to notify the other party. It will also talk about what happens if you do invoke force majeure. It may be that performance is suspended. It may be that the contract is terminated entirely. And it may also be that it's not, even if it is suspended, your performance is suspended, it may not be indefinite. So the party awaiting performance may still have the ability to terminate the agreement at some point in the future if the event goes on for a certain period of time. So again, that's a force majeure clause. Now, if you have a case where your contract does not have a force majeure provision, you're not entirely left without some sort of remedy. And that's when applicable law again applies. So depending on the law of the jurisdiction that your contract is subject to, there are doctrines such as impossibility and frustration of purpose. These are very facts and circumstances based as far as the analysis goes, so I won't get into it, but basically they're a lot like what they sound. If the supervening event that has occurred makes it impossible to fill your contract, then you would be talking about a defense or a claim of impossibility. If the event frustrates the entire purpose of the contract so that performance would be pointless, then you might have an argument with respect to a frustration of purpose. Stepping back a bit, as a practical matter, when you're thinking about how you're going to deal with your contracts, the first thing you may want to consider is, do you want to maintain the contract? It may be that you don't want to terminate it or suspend it, in which case communicating and reaching out to your contracting partners is often a good first step to see how you might be able to renegotiate the terms of the deal. If you do that, one of the cautions is to make sure you document it in the way that is required under the agreement. So most contracts will have a provision that says any changes need to be in writing and signed by both parties. So you want to make sure that you follow that and document it in the right way. And also, in having these conversations, you want to make sure that you always reserve whatever rights you may have available to you at law or in the contract itself. Again, this is a very broad overview. I think the key takeaway is to remember that if you can't perform or if your contracting party has suggested or told you that they're unable to perform, look at your agreements, be aware of applicable law, talk to your legal counsel before you make a decision as to how to handle it. And with that, thanks again. I am finished, and I'm going to turn it back over to Alex Pyle, who I believe is going to talk about some insurance issues.
Great, thank you, Paul. Since we're already slightly over time, I'm going to be brief, and I'm going to sort of cut to the chase on the insurance coverage topics. So just briefly, as with other types of contracts, and insurance policies are contracts, and they're not all the same. So just because you have business interruption insurance, that doesn't mean that that every business interruption policy is written the same way or will have the same requirements as to when you're entitled to coverage. So some policies for business interruption or acts of civil authority may require you to have some actual physical property damage in order to claim benefits. Others may not have that requirement. So the takeaway is you're going to need to look at your policy, look at the coverage, work with your insurance agent to determine what specific coverages may be available to you. Significantly, even if you think that coverage is questionable or you're not sure, the best bet is to put in a claim, put your insurer on notice, let them deny you if that's what they're going to do. But that way you've at least preserved your rights under the policy, and it may become clear in the future whether or not coverage is available. But you certainly don't want to miss the opportunity or just assume you don't have coverage and then forego the opportunity to get coverage if it turns out to be available. So that's in a nutshell the advice on insurance policies. That's the end of our formal presentation, but we do want to address some of the questions that have come in over the webinar during our time. So I will go to some of those now. For those of you who are able to stay with us for a few more minutes, we'll address those. If you can't, we certainly understand and want to be respectful of your time. So one question we received was about the forgiveness of PPP loans and whether if a loan is forgiven, does that constitute taxable income? Would you then owe income tax as it would for other types of loan forgiveness? And the answer to that is no. There's a specific provision in the CARES Act that allows PPP loans to be forgiven but not treated as taxable income. Another question that we received that I'll have Brian Bouchard speak to is about the FFCRA small business exception and whether it's on a blanket basis or does it need to be made case by case for a particular business.
Thanks, Alex. That's an excellent question. The regulations strongly suggest that companies have to move forward on a case-by-case basis when assessing the small business exception. Guidance from the USDOL strongly encourages employers to work in good faith with their employees and try to find a workable solution on a case-by-case basis.
Great. Thank you, Brian. Another question, maybe this is one for Peter, but we'll see who can take this one. A couple folks asked, well, we said you can't double dip in terms of the PPP loan forgiveness and the FFCRA credit. Does that mean you can't use those both for the same time period, but could you use them sequentially? Could you get 8 weeks worth of payroll forgiveness, their loan forgiveness for payroll costs, and then separately after that period or before, potentially use the FFCRA credit at a different time. So I don't know, Peter, if you have an answer to that, or Paul,
Yeah, I do.
Okay.
And Paul, you can jump in too, or Brian, whoever. But I think there's a little bit of a misunderstanding. Um, the the idea of can I take payroll protection program loan and receive certain credit benefits. For the FFCRA, you can receive the benefit, but the benefits paid under FFCRA are not included in payroll costs of the calculation of the loan amount or the amount forgiven. The retention credit, on the other hand, you cannot take if you also get the PPP loan. So you have to distinguish between the two types of credits. There's no double dipping, but it's a different kind of double dipping in each case.
Great. Thank you, Peter. Another question we've received is about a business or an LLC or a small business that has no W-2 employees, but only has one or two owners or members. Can those individuals be considered employees in this case for purposes of the EIDL loan? Would they be treated as employees, or would you say that you have no employees since you don't have anyone actually receiving W-2 income from the business? Paul Royland, do you have a thought on that, or have you seen guidance on that?
I haven't seen any specific guidance on that, but my inclination would be that they would not be treated as employees.
Great. Another question we received was whether, also relating to the EIDL loan and the grant component of that, whether you can apply for the grant component without applying for an EIDL loan itself, if you just want the grant and not the loan. Paul, do you want to speak to that one?
Sure. Yeah, we've had this question quite frequently. When an applicant submits their documentation for an EIDL loan, they will be asked whether, by checking a box, whether or not they would like to be considered for an advance of up to $10,000. So I guess that's a long way of saying that the grant and the loan are part and parcel, and that there is no separate application, only the grant. I would say that simply by virtue of submitting an EIDL application, there is no obligation to accept any loan funds in the event that you were approved.
Great. Thank you, Paul. One final question, and I'll throw this one over to Brian, is whether there's any kind of a full list of specific special circumstances related to children greater than 14 years of age, who might then be, if you're.
Yeah, it's a good question. I have not seen a list of what might qualify as special circumstances. But I do know that the IRS is requiring the employee to provide a statement of the special circumstances that exist for the employee to be caring for someone over 14 years of old during daylight hours.
Great. Thank you, Brian. That concludes the question section of our presentation. I want to thank everyone for joining us today. If you have questions, our contact information is here. I'd also encourage you to visit the COVID-19 page of the Sheehan Finney website at sheehan.com. We have posted a lot of client alerts there. There's a lot of useful information and links to other resources as well. We encourage you to take advantage of that. Finally, I would just say that these are difficult times for many people, challenging times for all of us. There's a lot of complex legal issues raised, and we're here to help you. And we also hope that you and your businesses and your employees all can stay well and healthy during this time. Thanks for staying with us, and apologies for going a bit over the allocated time. But we look forward to having many of you join us again for our next webinar next week, and hope that we can see you all on the webinar and in the not too distant future in our offices or on the streets. Thank you and be well.